A recent case out of the Court of Appeals of the state of California brings up some interesting questions. First, does someone have the legal right to tell you how to refer to them? Second, does a mental disorder give someone the legal authority to infringe on the rights of others? The opinion in this case shows the irrationality of both the transgender activists and the judicial branch, which leads me to another question. Is the mental confusion we call transgenderism contagious? So we'll discuss that next on the Constitution Study.
There's one thing you have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello there, everyday Americans. Paul Engel here, and welcome to the Constitution Study. I am glad you could join me. As always, you can find out more about what I'm doing. Go to constitutionstudy.com. You can find these articles, videos, podcasts, audio, whatever it is, you can generally find it starting there. Now, I'll talk more about what's available and what you can do at the end of this video, but I want to jump right into this case out of California involving transgender rights. The case in question, taking offense versus state of California, stems from California Senate Bill 219, which added code to the state's health and safety code called the Lesbian, Gay, Bisexual, and Transgender Long-Term Care Facility Residents' Bill of Rights. Taking offense challenged two provisions of this law. Except as provided in subdivision B, it shall be unlawful for a long-term care facility or facility staff to take any of the following actions wholly or partially on the basis of a person's actual or perceived sexual orientation, gender identity, gender expression, or human immunodeficiency virus status. Subsection 3, where rooms are assigned by gender, assigning, reassigning, or refusing to assign a room to a transgender resident other than in accordance with the transgender resident's gender identity, unless at the transgender resident's request. And then subsection 5, willfully and repeatedly fail to use a resident's preferred name or pronouns after being clearly informed of the preferred name or pronouns. First heard in the state Superior Court, the decision was appealed to the state's Court of Appeals. Now, the appeals court started with the First Amendment challenge in subsection 5. Taking offense listed 4 specific problems with the speech requirements of the law. 1. Prior restraint on speech. 2. A violation of the freedom of thought, comparing transgender residents of long-term care facilities to kings and masters over the rest of the people, and employees of long-term care facilities to their virtual subjects and slaves. 3. A violation of the freedom of conscience, religion, and belief. And 4, a violation of the right to free exercise of religion. The court agreed that subsection 5 of the law is a content-based restriction on freedom of speech. Now, the court went on to explain, the First Amendment to the United States Constitution states, Congress shall make no law abridging the freedom of speech. This fundamental right of free speech applies to the states through the 14th Amendment's Due Process Clause. As I've stated more times than I'd care to remember, this cannot be a First Amendment issue since Congress did not make this law. The legal fiction that the First Amendment applies to the states via the 14th Amendment's Due Process Clause was made up out of thin air by the Supreme Court to federalize cases that the Constitution does not treat as federal issues. Now, when this court focuses on the First Amendment, it does note that the protections of freedom of speech in California comes from the California Constitution. Similarly, Article 1, Section 2, Subdivision A of the California Constitution provides, every person may freely speak, write, and publish his or her sentiments on all subjects, being responsible for the abuse of this right. A law may not restrain or abridge liberty of speech or press. Article 1's Free Speech Clause enjoys existence and force independent of the First Amendment to the federal Constitution. While we are free to speak, write, and publish on all subjects, what is stated in the California Constitution applies to the federal one as well. We are responsible for the abuse of this right. Now, often erroneously called the prohibition on yelling fire in a crowded theater, we see this most often in libel, slander, and perjury cases. You cannot lie under oath or slander someone, then claim exemption from punishment because of free speech. The state of California claims its compelling interest in preventing misgendering is sufficient for them to regulate free speech. The court agrees. We agree with the Attorney General that the state has a compelling interest in eliminating discrimination on the basis of sex. The High Court has recognized that discrimination on the basis of sex includes discrimination on the basis of sexual orientation or gender status. While the High Court may recognize that a person's belief is equivalent to physical properties of sex, the Constitution of the United States does not. The Bostock versus Clayton County decision the court refers to is simply another example of the oligarchs on the Supreme Court placing their opinions above the supreme law of the land. Thankfully, in this case, government interest alone is not considered sufficient to infringe on your rights. The court found that alternatives to restricting speech showed that the government's case was insufficient to allow it to criminalize speech. Now, in regards to free speech, though, we have a final question. Does the use of a pronoun other than the one preferred rise to a level of injury as to require state sanction? The court rightly found that it does not. The pronoun provision at issue here tests the limits of the government's authority to restrict pure speech that, while potentially offensive or harassing to the listener, does not necessarily create a hostile environment. As the Third Circuit Court of Appeals has recognized, quote, where pure expression is involved, anti-discrimination law steers into the territory of the First Amendment, close quote. Now let's take a look at the challenge to the room assignment requirements based on the Equal Protection Clause. Taking Offense contends the room assignment provision violates the Equal Protection Clause of the 14th Amendment of the United States Constitution, Article 1, Section 7 of the California Constitution, and the Unruh Civil Rights Act. It makes two implicit assumptions about the room assignment provision. One, the provision requires a facility to accommodate a transgender resident's request to be assigned to a room other than in accordance with the resident's gender identity. And two, a resident's request to be assigned to a room other than in accordance with the resident's gender identity is equivalent to dictating the gender or gender identity of the resident's roommate. Based on those assumptions, Taking Offense asserts the provision grants transgender residents special rights to choose whether to be assigned a roommate according to the transgender person's gender identity or the person's assigned sex at birth, while failing to recognize the same right of non-transgender residents. We disagree. The question at hand is if California's room assignment provision of SB 219 unlawfully requires people to be treated differently under the law. A quick look at the language should make this perfectly obvious, since the roommate requests of two residents are treated differently depending on whether one of them claims to be transgendered. Consider this example. In any room sharing situation, there are at least two people who will be sharing a room. If the room assignments are made according to sex, then the facility has a physical basis for making those assignments. However, if the room assignments are based on gender identity, the decision is based on an arbitrary decision of only one of the residents. Now consider the situation where a woman is required to share a room with a man because he claims he is a woman. Not only is the roommate request of only one of the residents considered, but only the transgendered person is allowed to make such a request. This is not to be done based on a physical or medical condition or even based on a legal relationship between the residents, but solely on the subjective assertion of one of the residents. Sounds pretty unequal to me. Apparently, though, this obviously discriminatory practice is not so obvious to the court. The Equal Protection Clause requires the state to treat all persons similarly situated alike, or conversely, to avoid all classifications that are arbitrary or irrational, and those that reflect a bare desire to harm a politically unpopular group. Aren't two or more residents in a long-term care facility who will be sharing a room similarly situated? Is the determination of sexual orientation arbitrary or irrational? Does the denial of the right to request a roommate of a specific sex to anyone not currently identifying with a group currently politically favored in California show a desire to harm a politically unpopular group? I would say the answer to all three of these questions are yes. Apparently, this is too difficult for the members of the court to understand. This provision creates a general rule and an exception to the rule. The general rule makes it unlawful for a long-term care facility or facility staff to assign, reassign, or refuse to assign a room to a transgender resident other than in accordance with the resident's gender identity. This requirement provides no special rights to transgender residents. Rather, it only clarifies that gender-based room assignment decisions involving a transgender resident must be made according to the resident's gender identity rather than their biological sex at birth. According to the members of the court, the fact that only the transgender resident gets to decide the sex of their roommate does not make that a special right. However, I must ask if what they want or desire rises to unequal treatment in this court's eyes. Not only do they not see the unequal treatment of forcing a female resident to live with a male resident against her will, but the gross abuse of her rights. Somehow I think only a lawyer or a judge could be so deluded. Perhaps we should not be surprised that this opinion came out of California. Based on other recent cases, I fear this elevation of a mental disorder above the supreme law of the land will be with us for quite some time. So in this split decision, we have one part which follows the law and protects the legitimate rights of everyone, while the other only cares about a politically favored group. Apparently, justice is not so blind as one would assume from looking at her statute. While staff at long-term facilities in California will not be forced to keep a running track of who wants to be called what, the residents there are being forced to bow to the god of transgenderism. It seems we've thrown reason, logic, and evidence out the window when a man can claim to be a woman or vice versa, and everyone is expected to act as if they were actually true. If a man with this disorder wants to share a room with a woman, I don't think the state should be involved. That means the state should not deny the request, but neither should it force a woman to comply against her will. This opinion not only elevates those who suffer from the transgender mental disorder, it dehumanizes the vast majority of people who do not. In California, if you are not transgendered, you're a second-class citizen, and your rights only matter if the transgendered allow it. This disease is spreading across the nation. Are you prepared to defend yourself, your rights, and those of your family against these attacks? Now, I've said it before. I don't have any animosity to somebody who's confused about their gender, who thinks they were born in the wrong body. I have pity on them. I have sympathized with them. But I don't give them the authority to force their delusion on everybody else. That is not freedom and liberty. That's tyranny. Now, again, if a transgendered person wants to share a room with somebody of a sex and that person doesn't have a problem with it, hey, I don't care. But to say that of the two or more residents in a room, only one of them gets to decide the gender they will be roomed with, well, that's unequal treatment under the law, is it not? A blatant violation of the 14th Amendment, but too much for this court in California to understand. Again, this is California, so I'm not terribly surprised. But how long before this comes for you? How long before those in Chicago, New York, and eventually even Nashville, Paducah, Kentucky, and who knows where, are bowing to this idea that the only people who get to decide truth are those who are confused about their gender? To take the physical aspect of sex and suddenly mutate it into some arbitrary decision made by one person, well, that's not fair, it's not just, and it's not right, but it is where America is going. And we have to stand up and stop it. That means recognizing the irrationality of this court's opinion and calling it such. And if you live in California, possibly even ignoring it. Well, it is an action of a delegated authority contrary to the tenor of the commission under which it was formed. The Supreme Court of California was created by the Constitution of California, which has its own equal protection clause. We need to start standing up for our rights and stop expecting government to do it for us. They have failed over and over and over again. How often are we going to expect government to protect us only to be disappointed before we stop depending on them? How often do you sit in a broken chair before you realize it's not going to take your weight? Now, what can we do about it? Well, the first is education. That's why I do these videos, to help you understand the details and the concepts behind both these opinions and what the Constitution actually says. Now, you can take this and share it. I create this for you. You can use it. You can share it absolutely free. You can find it on YouTube, at least until they kick me off. You can find it on Rumble. You can find it on my website, constitutionstudy.com. Use it, teach yourself, teach your family, share it, absolutely free. That's the basis of the Constitution study. We read and study the Constitution. We teach the rising generation to be free. Now, if you want to do some more, well, here's a couple things you can try. I do have, twice a month, I hold a live question and answer. You can watch it streamed live on YouTube and Twitter. Soon I'm hoping to be on Rumble as well. Or you can join the Zoom call. Just go to constitutionstudy.com/events, and you'll find the Constitution live Q&A, register. So you can either watch it on YouTube or Twitter, just 7 p.m. Central Time, or you can register and join us in Zoom. Either way, it's a place for you to get questions asked and answered. If you want to get into more study, if you want to become a scholar yourself, a student of the Constitution, well, then head to constitutionscholars.com. I set that up specifically for people who want to learn more. They want to be students. You can sign up for free. It does require you to register, but it is absolutely free. You get access to a library, to videos, to classes, most importantly, to community groups. This is where you can find others that are also interested in studying, where you can share ideas, share questions, start discussions, be involved, be engaged, make friends online so that you can study the Constitution together. Now, if you want mentorship in this, well, there is a program. I would ask you to check out the Apprentice program on Constitution Scholars. That is not free, but it's only $5 a month, and I'll give you the first month free. So check all that out. These are all tools to help you become a better student of the Constitution, to defend your rights, the rights of your family, and the rights of the rising generation. Hopefully, you found this all useful. You'll come back here next time for the Constitution Study.
There's one thing you have to know wherever you make your stand. Came from